everybody. My name is Jason Carr, Mayor of Morris Plains, and proud to hold that title. Thank you for coming out tonight. This is going to be an information session for our affordable housing obligation. I just want to recognize some people, and of course it's the mayor and the council, and we have Sal Cortez as our council president. We have Nancy Berger with us tonight. Art Brune, we have Bill Houston with us tonight. Tyler Pontier is with us here tonight, and Michael Ivey. On the planning board, we have Mike Garabaglia as the chair. He's sitting up here tonight. We have John Bezel, who is with us here tonight. Myself, we have Mary Ann Steckert, who is here tonight. Again, Bill Houston is a liaison. Steve Augenblick. We have Sue McCluskey, who is a member of the planning board with us tonight, and Andrew Wolf. Beginning of 2024, can everybody hear me okay? Just want to make sure everybody can hear. In the beginning of 2024, I assembled an affordable housing committee, and I asked Dave Schultz, who is with us up here tonight, to be the chair. Art Brune is on that committee, along with Frank Dretzler. We have Mike Garabaglia. We have Bill Houston on it. Suzanne McCluskey. We have our affordable housing attorney, Ed Buzak. We have Bill Ryden, our engineer, and Liz Laney, our professional planner, is on that committee. Also with us tonight is John Horan, is our borough attorney. So we put this committee together in 2024. I believe our first meeting was in April of 2024, just to get our ducks in line so we're prepared for this fourth round of affordable housing. We had several meetings, and we got our numbers, which Ed will speak to, and how we got there, and we've gotten that down to a very reasonable number, I believe. And I think Morris Plains is really in a good spot with everybody's input and knowledge and background of affordable housing. So, without further ado, I'm going to have Mr. Buzak explain where we've been, where we're going, and how we got here. And then at the end, we'll open it up to questions for whatever you have. So we have the handouts over here on the top of the stage. If anybody needs one or sees somebody that doesn't have one, just come on up. Feel free to take a handout. It gives some background information and some information that we're going to use going forward. So I'd like to introduce Ed Buzak, our affordable housing attorney. Mr. Buzak.
Thank you, Mayor. Thank you for coming out tonight to listen to us speak about affordable housing. It's not the most interesting topic.
We can pause the microphone. Yes.
Is that better?
Yes.
Is that better? Okay. But I've been in this field really my entire career. So for me, it's relatively interesting. I'd like to start out by just giving you a context so you can understand what the borough and all the municipalities, most of the municipalities in the state of New Jersey were faced with. And then I think you become, you'll better understand how we had to react and why we reacted the way we did and how we accomplished what we accomplished. The handout in the first 10 or so pages goes through the history of affordable housing in New Jersey, starting with the Mount Laurel decision, which was in 1975. I'm not going to go all the way back to 1975. I'm actually going to start in 2024. But I do ask you, if you have the opportunity to look at those first 10 or so pages. It's a good summary of the history of affordable housing in New Jersey and how we got to where we are. In 2024, the legislature adopted what's known as the Fair Housing Act amendments. The original Fair Housing Act was adopted in 1985, 10 years after the Mount Laurel decision, and it hadn't been substantially revised until 2024. And again, I won't go through the history as to why that happened, but it did, and it eliminated an administrative agency that since 1985 had dealt with affordable housing obligations in the state of New Jersey and gave municipalities an opportunity to administratively, through an administrative process rather than a judicial process, have a determination made that it, the municipality, was satisfying its affordable housing obligation. In 2024, the Fair Housing Act Amendment abolished that entity and substituted another semi-judicial or quasi-judicial agency in the judiciary system as opposed to the executive branch of government that would administer the affordable housing obligations in the state of New Jersey. And that's, they named it the program, which isn't very original, I guess, and is somewhat awkward when you try to speak about it, but you'll hear me talk about the program, and what I'm talking about is not what you believe is a program. It's a group of 7 retired judges of the Superior Court of New Jersey who were designated to deal with these affordable housing issues. The first thing the amendment to the legislation or to the Fair Housing Act did was to establish a method to determine the magnitude, the number of affordable housing units that would have to be created in the state of New Jersey over a 10-year period. That's known as round 4. It runs from 2025 to 2035. And the formula that they created is a relatively simple one. It's not a particularly accurate one, but it's a simple one. And what they did was they said, look at the number of households that were created between the years 2010 and 2020. Take 40% of those households, and that is the number of low and moderate income households that we, the legislature, predict will be created over the period 2025 to 2035. So, you know, I think if you step back a minute, that data, by the way, is census data. You just go to the decennial census in 2010 and 2020, and you can find that information out. And if you take 40% of that population change, they determined that would be the number of low and moderate income households. And that 40% is a number that's been sort of traditionally applied in prior rounds over the years in affordable housing, that about 40% of the population is considered low and moderate income households. And the handout points out that a moderate income household is defined as being a household based upon household size, so the numbers vary. But it's a household that's earning between 50 and 80% of the median income in the region. And a low-income household is a household that's earning under 50% of the median income. So the categories are defined based upon income of a household. When you take 40% of the households that were created between 2010 and 2020, you come up with 84,698 households. So, following the methodology, the state of New Jersey has to come up with zoning that will allow for the construction of 84,698 units of affordable housing to house those families that are anticipated to be created over the 10-year period, 2025 to 2035. So now the next step is, okay, we know how many units have to be created in the state. Again, you can accept it or not accept it, that's what the law is. But we have to allocate that. How do we do that? How do we allocate that? So the first thing they do is they created, and this was all part of some of the old law as well, they created 6 regions in New Jersey. A region is between 2 and 4 counties, or 1 and 3 counties. We have 21 counties, there's 6 regions. Morris Plains is in Region 2, and the numbers are just sequential, they're meaningless, but we're in Region 2. Region 2 consists of 4 counties, and it's Warren County, Union County, Morris County, and Essex County. And if you think about that, you have an urban area, Essex County, you have sort of a semi-urban county, Union County, you have a more rural county, Warren County, and then you have Morris County, which is, I guess a traditional suburban county. And they tried to create the other counties. There's 6 regions in the state comprised of counties. And they tried to create them to include at least 1 urban area within each of the regions and 1 rural area within each of the regions. That doesn't work all the time, depending upon where you go in the state. So the first thing they did was divide that 84,698 into those 6 regions, allocate each region with a number. And they did that mathematically, just based upon the number of municipalities within those regions. Our region, Region 2, was assigned a number of 20,504 or 506. 20,506 units. So of the 84,698 statewide, Region 2 has to create an opportunity for 20,506. Okay, so now you got it down to the regions. Now you have to get to the municipalities because we are the ones who zone and create the opportunities for housing to be constructed. So how do you do that? What's the formula for doing that? The legislation came up with this formula. They took 3 factors, they added those 3 factors together, divided by 3 to get an average, and applied that average to the regional average, and you took your percentage of that. So, what are the 3 factors? The 3 factors are one that should be obvious and proper, land capacity. How much land do you have? So how much developable land exists in Morris Plains as compared to the amount of developable land in the region, in that 4 county region? What's the percentage? Then they took 2 other factors that one can argue about forever. One of those 2 was an income factor. How does, and this is a simplified explanation, it's a little more complicated than this, but in general, it was how does the average income in Morris Plains compare to the average income of the region? And then they took a 3rd factor, which is called equalized non-residential valuation. As you know, all of the real estate in New Jersey is assessed. You pay taxes based upon an assessment that's on that property. There's residential assessment, there's non-residential assessment. The theory is that in some municipalities, non-residential development was encouraged over residential development. And those municipalities, the theory goes, reaped many benefits from that. They got in substantial tax rateables, meaning substantial tax income, but they didn't have they didn't have to perform the services, they didn't have the costs that residential housing generates for a municipality, particularly school children and school costs. So the idea was, again, you can agree or disagree with it, the point is, this is what the law says. The theory was, well, those municipalities that encouraged non-residential growth were chasing rateables, as the phrase went, ought to pay for that. They ought to now, the chicken should come home to roost, and they ought to now help support the residential growth that's occurring elsewhere, because these non-residential facilities, office buildings, warehouses, well, less warehouses, office buildings and other non-residential development produce jobs. You need workers, you need employees. Those employees need to live somewhere, and the municipality in which they were working was not necessarily a municipality in which they were living, because they couldn't afford to live in the municipalities that were chasing the ratables. That's the theory. So they compared the non-residential evaluations in Morris Plains over the period 1999 to 2024, and there's an explanation for that, but I need not go into it. It wasn't just between 2010 and 2020 or 2015 and 2025. It was a 25-year period. But anyway, they compared what your non-residential ratables were in 1999, what your non-residential ratables were in 2024, and compared that growth, that difference, to the difference in the region. So you have three factors, and Morris Plains numbers were compared to the region's numbers, and that produced a percentage. You added the three together, you divided by 3, you came up with a number. And that percentage was applied to the 20,506, remember that number I was talking about, for the region, and Morris Plains got that share based upon that allocation formula that I just went through. That produced a number, which was 137 units. So Morris Plains was responsible for 137 affordable housing units, right? 137 affordable housing units for the next 10-year period, which is not an outrageous number. It's a high number for a municipality like Morris Plains, because it's largely developed. There's just not a lot of areas in which growth can take place and where you can produce 137 affordable housing units. Now, many of you are probably aware of this concept of inclusionary zoning, where a developer builds a development and he or she or it allocates 20% of the units being constructed as affordable units. The other 80% are market units. So with a number of 137, if that were satisfied completely through inclusionary zoning, there would have to be 5 times the number of units built in Morris Plains, so that 20% of them would equal 137. So when you look at it that way, it's not such a small number. Again, for a borough the size of Morris Plains and with the characteristics that Morris Plains has. But anyway, that's the number. And the legislation said that's the number that the Department of Community Affairs calculates, here's how you do it. And they did it, we got our number. The legislation also, however, provided that a municipality could challenge that number if they felt that the allocation factors that were being utilized were erroneous. Now, you couldn't challenge the census data because that is pretty clear. You couldn't challenge the 40%. 40% is 40%. It's math. Once you figure out what the difference is and you take 40%, you can't challenge the 40%. You couldn't challenge the allocations to the regions because those were based upon that 84,698. So the only thing you could challenge are those 3 factors: land capacity, income, and non-residential valuation. 2 of those 3 factors are also largely non-challengeable. Non-residential valuation is a number that's reported to the state every year. Anybody can look at the records, add up the numbers, and you'll come up with a number. And it's really non-challengeable. And the same thing then, obviously, for other municipalities when you add up the regions. So that was a factor that really was very difficult to challenge. The income factor is again based upon census data, and that's difficult to challenge. It is what it is. The land, the developable land, that's another thing. And it's another thing, not because it's so hard to figure out developable land that's vacant versus non-developable land that's vacant, but the Department of Community Affairs used mapping from 2020. So their mapping was 4 years old and was not necessarily accurate. So we were able, we in Morris Plains, this is largely the planner in Morris Plains, Liz Laney, was able to look, and the engineer, Bill Ryden, were able to look at the land that the state said, the vacant developable land that the state said Morris Plains had, versus what we really had, because we know what we really have. You know, we're boots on the ground. And between Liz and Bill and others, we were able to determine that the state had allocated much more vacant land to Morris Plains than we actually had. And therefore, that formula, of which vacant land was developable land was one of the factors, that formula was wrong. We got a higher percentage than we should have gotten. So again, without going through all the math and all the numbers, it turned out that when we did that, and we reapplied the formula to that 20,506, we didn't come up with 137, we came up with 106, right? 106. So we said our number's 106, it's not 137. Now, again, that's not a vast difference, it's a 31 unit difference, but if you multiply that by 5, it's a 155 unit difference. So, you know, everything counts. So Morris Plains challenged the number. We went through the process in early 2025, in January through April, actually through May, and we said our number should be 106. It should not be 137. And ultimately, I'm happy to say we prevailed. And the program accepted our number, and our number was reduced from 137 to 106. Again, you know, that's 150 total units, 155 total units if you're doing it by inclusionary development. But then the question still is, okay, where are we going to put 106? I mean, we could put 137. 106 is better, but we're going to put 106 or 5 times 106. You know, 530. Where are we going to put those? Well, again, the legislation created one more step that we were able to take, and we, being all municipalities, were able to take. If at the end of the day, we didn't have enough land available to construct the units, because remember, that allocation was not just based upon land, it was based upon income. You can't build housing on income. It was based upon non-residential valuation. You can't build housing on non-residential valuation. Those are numbers, those are factors. That's not tangible land. What is there is tangible land. That's, at the end of the day, that's really what controls how much growth you can accomplish. Leaving outside redevelopment of areas, you know, which again, I don't want to get into all of that, but in general, in a simplified form, land is the thing. That's the factor that controls how much development you can really accommodate. So the law gave us the ability to adjust that 106 number to a different number based upon lack of vacant developable land. And the characteristics that are used, the criteria that are used are a little different when you're doing this analysis than when you were doing that land capacity analysis that we did before. So we went through that process. And again, the planner spent an inordinate amount of time. This committee that the mayor talked about spent an I don't want to say in an inordinate amount of time, it was time well spent, but it was a tedious effort that the committee went through, that Liz Laney, our planner, went through to analyze all the data, analyze every single parcel of vacant land in this borough, and determine whether, by a series of criteria, whether that land qualified as vacant developable land that could accommodate growth, accommodate residential growth. And what it determined was that we were nowhere close to being able to accommodate the 106 units. The housing element and fair share plan that will be up before the planning board for a public hearing on the 16th? Right, 16th, yeah. On Monday the 16th, proposes an allocation, it's known as a realistic development potential. Those words make sense to you, right? You know, these are not theoretical numbers. This is a realistic development potential based on real land that's developable that we have in Morris Plains. That, the Housing Element Fair Share Plan takes the position that our RDP, realistic development potential, is 10 units. So it's not 137, it's not 106, it's 10. And for those of you who are all here, you know, I think that makes some sense to you. You know, given your knowledge of Morris Plains and you know, what Morris Plains is and how much land is available and the character of the municipality and so forth and so on. So the Housing Element Fair Share Plan takes the position that our realistic development potential is 10. And that is what we have to satisfy. Now remember, 10 is the low and moderate income units. So if you're going to do that by inclusionary development, just straight off the top, you'd have to construct or have realistic zoning to construct 50 units with a 20% set aside, which would give you 10 units. The plan that has developed, that's on file in the clerk's office, and that you can look at, it's online, I believe. You can go on the website and find it and look at it. It proposes that those 10 units be satisfied in a variety of ways that are permitted under the new law. And I won't go through all the details again. You can look at that on the website. But it consists of some carryover credits that we got from the third round, because, again, when you look at your handouts, you'll see we went through the first, second, and third round. This is the fourth round. And in the third round, we produced excess units beyond the obligation that we had, because that's just the way it worked out. You know, not that we were trying to do that, it's just the way the numbers fell out in the various developments. We were able to carry forward, I think it was 3 units or 2 units from round 3, so that brought the 10 down to 8. There's also credits for group homes, for bedrooms in group homes, and we were able to accommodate 2 units, 2 bedrooms, which count as 2 units for the purposes of this, so we were able to put those in there, which got us down to 6. And then there were other things, and again, I won't go through the details, but we got down to satisfying the 10, and one of those components involves an overlay zoning, which may turn out to be a rezoning of one site, and it's a site. Again, I think it's in the handout right there. And this one, you can look at your handout if you haven't been looking at it before. I think we have a color second to last. There's one site, one inclusionary site, so to speak. It's block 112, lot 2, 100 Campbellwood Drive. It's right off Route 10, and right across from the Sinester Suites building that is the extended stay building. That's there. And you'll see it with a star on the page.
So just let me interrupt 1 second. So if you're traveling on Route 53 towards the recycle center, you're going to pass the recycle center, you're going to come to the traffic light at Foxwood. The road veers off, there's a ramp there that goes out to Route 10. As soon as that road veers off, there's a wooded area right before Candlewood Drive. That's the parcel of land that we've identified for our affordable housing, just so everybody's a little bit more familiar with what Ed's talking about. So it's across the street from Foxwood. It's catty corner from where our other affordable single standalone affordable housing building is, 260 Table Road. So it's down in that area, just past the recycle center.
If you look at that sheet, it really gives you the statistics that were being contemplated at the time that were finalized in the Housing Element and Fair Share Plan that's online. The lot's about 1.77 acres. The density would be between 15 and 20 units an acre, with a 20% set aside. If it were 15 units an acre, it would produce a total of 27 units, of which 6 are affordable, and then at 20 dwelling units an acre would produce 36 units, of which 7 are affordable. It turns out that when you look at the Housing Element Fair Share Plan that's online, it's right between those two numbers. It's 17 units an acre. And the reason that you may say, well, why is it that high? Because you just told me we got some credits and we don't have to do 10, we have to do less. The answer to that is that there's one more component that I purposely neglected to talk about until now. The additional component that the Fair Housing Act Amendment imposed involves only those municipalities that took advantage of this vacant land adjustment. You know, in other words, had an allocation, as we had, of 137, 106, and said, no, we can't accommodate any of that, we can only accommodate 10. Other municipalities, obviously, in the state have done the same thing if the circumstances are similar. And for those municipalities that did that, and only those municipalities that did that, there was one additional obligation. And that one additional obligation was you were required to provide what's called realistic zoning. Not sure what that really means because it's not defined in the act. But to provide realistic zoning for 25% of your RDP. So remember I said our RDP was 10, 25% of 10 is 2.5. You don't create 2.5 units, you always round up because it's at least 25%. So we had to create realistic zoning for 3 units. So what we did was put that all in the one site, which is why the density is a little bit higher to produce those additional units and satisfy that 25% obligation. So overall, that's the status, the current status of Morris Plains affordable housing obligations, how they were determined, how the committee worked to deal with them, and you know, I've been doing this my whole career, as I said, and currently I'm involved in 13 municipalities doing this and doing the same plans in Morris County and Bergen County. And I have to tell you that the effort that was put in here, and I know you'll think I'm saying this because I'm here, but the effort that was put in here was substantially greater than a number of municipalities. Now, some of them didn't have the challenges that we had, some of them didn't have the situations we had, some of them had done vacant land adjustments in round 3, the prior rounds. So unless God creates more land, nothing's changed, you got a pretty easy row to hoe in round 4. Morris Plains did not have that luxury in round 4 because they didn't have a vacant land adjustment in round 3 because they couldn't. They couldn't qualify for it. But the effort that was put in and the results, I think, are really outstanding. When you can come out of this starting with 137 units, come down to 10 units, and then be able to use a number of mechanisms to bring that down to rezoning one site of 1.77 acres, that is off Route 10, near, the mayor described this location, and you people know its location better than I. I think that the committee needs to be commended for that. They did a good job. Now, I'd like to say we're done, but we're not. This, and I'll just go through the rest of the process here so you know. Once the planning board conducts its public hearing on Monday and hopefully adopts this housing element fair share plan, it goes to the mayor and council. And the mayor and council need to endorse the plan. I mean, they don't need to, they could say, we're not going to endorse it, but the process is, if they agree with it, they endorse the plan by simple resolution. It's not a public hearing, it's not a big deal. They endorse the plan, and then we, the attorneys, file that with the program. Remember that program that I talked about at the beginning? We file it with the program. That activates a 62-day period, July and August, for anybody to object to the plan. Okay, so any person can object to the plan and say that it's deficient, doesn't follow the Fair Housing Act, doesn't create a realistic opportunity for the construction of these units. It can say whatever they want to say, tied to the law, not tied to, hey, I want to build it here, I have a better site, I want to buy these 3 houses, knock them down and build, a 50-unit development there, that's where we should put it. That's not the way the objections work. The objections work to look at your plan and say, it's not realistic, you can't accomplish what you say you're going to accomplish. And again, from my experience, looking at what we've done, the effort that's been put in, and the location of this property, I think that's going to be a tough road to hoe for somebody to successfully object to it, but they can. If there's an objection filed, there then is a process through this program of trying to resolve that objection. Through a settlement process, if that doesn't work, then there's actually, it's called a session, another descriptive word, where one of those 7 judges that I talked about before hears testimony from the experts, from the planner, our planner, whoever's objecting, anybody else that wants to weigh in, and makes a determination as to whether our housing element fair share plan meets the criteria of the law. If they find that it does, then they make a recommendation to a sitting judge in Morris County, who then can enter an order saying the housing element fair share plan is accepted, it's correct, it satisfies your constitutional obligation. Or they can determine it does not, and you have to go back to the drawing board. You did something wrong. What could that be? I don't know. They could look at your credits and say, no, you can't get credit for this group home because all paperwork isn't filed. You excluded vacant land as not being developable when it is developable. We feel strongly that we followed the rules, we did everything right, and that's the way we should feel at this juncture. But third parties can disagree with that, and ultimately somebody else is going to make a decision. And if they make a decision that's adverse to us, then we go back to the drawing boards and try to correct whatever the error is. If there is none, then we implement what we have. At some point in time, and it should be by the end of the year or a little bit later in early 2026, this will be over. We will know what the rulings are, what we have to do, and we will get what's known as compliance certification. And what that means is that you, Morris Plains, have satisfied your constitutional affordable housing obligation for the next 10 years, between 2025 and 2035. And what that means in the real world is that interested party that I talked about who says, I'm going to acquire 3 or 4 units, houses here, I'm going to knock them down, I'm going to build something, I'm going to build units there, they can't do that because the program and the sitting judge ultimately has determined that you've already satisfied your affordable housing obligation. If somebody comes in with a proposal and it's acceptable, different story, that's fine. You still have all those rights that you would otherwise have, but you are protected from people coming in and forcing you, which is known as a builder's remedy, forcing you to rezone property. And again, if you look at your handouts at another time, you'll see that we, Morris Plains, were involved in a builder's remedy lawsuit some years ago, and that resulted in a large number of units being constructed. We worked it out as best we could, and I was involved in that back then, so I have some familiarity with it. But in a builder's remedy situation, you're on the wrong side of the fence, all right? You are the ones who have to prove your case as opposed to the other side proving their case. It shifts the burden of proof, and that in the law is a tremendous factor. Who's got to prove what? And if you think about criminal law, what the prosecution has to prove, defense has to prove nothing. They don't have to prove they're innocent. The prosecution has to prove that they're guilty. That's the burden of proof. When you're involved in a builder's remedy lawsuit, we, Morris Plains, have to prove our case as opposed to the opponent having to prove theirs. That's the difference. And that's, in the legal world, that's a tremendous factor in terms of protecting the municipality. So, anyway, I think I'm done. I apologize for being as long-winded as I have been. But that's the story. Mayor, I'm going to pass it to everyone else.
Thank you, Ed. I know that's a lot in a nutshell, and it's a lot to comprehend, so I hope there are some questions. But before I do go out for questions, just Dave, if you have a couple comments on the process, and maybe just the timeline, just explain the timeline a little bit.
Sounds good. And for those in the audience who don't know me, I'm an architect and planner, been on the Board of Adjustment for about 20 years, longtime volunteer here in Morris Plains. Sue and I were on the Minutemen. I just wrapped up my 21st year there and am now retired. If you came to this presentation for clarity and logic, you're not going to walk away with it. And that is not the fault of our attorney. It's not the fault of this borough. It is among the most confusing bits of legislation I've ever seen and we've ever seen. There's a few things I'm going to overlay on Ed's presentation. One is that this is a linear process prescribed by law, and there's about 9 steps that take 17 months. And this handout, this part of the handout explains that. Within those 9 steps, 3 of them were absolute deadlines that every municipality had to hit or face penalty. And the penalty was loss of immunity from builders' remedy lawsuits, right? So the law said, you shall have this info on this day, end of story. And the law also said, the state, the program will respond within X days. And they don't, and they didn't. And there was no relief allowed by law So municipalities got decisions weeks late and still had to hit the next deadline. That's one piece to note. Two is, it took me a while to understand this, but the early numbers are abstractions and a step along the way to get to this ninth step. So the 137, the state never expected Morris Plains to be able to build 137 affordable housing units. It was step one in a multi-step process that we would eventually conclude in March of 2026. And it was very linear. You weren't allowed to work parallel. So 137, next step, look at your land. The state in the law said, you know better than us. The state, when they issued the 137, included maps, and the Morris Plains maps included parcels that were the size of my driveway. It included parcels that were built on top of train infrastructure. It included the VFW hall. And we know that those are mistakes. So those mistakes were corrected, and that's what resulted in the 106. So the 106, again, was an abstraction. It's a step towards the final number. The state never expected us to build 106. So the number we're now at is the realistic development potential. And I think we've now arrived at the accurate number as prescribed. Two other things. Vacant land is not vacant buildings, right? Two separate things. So the vacant land adjustment is just that. So if you look around the building, the borough, and you see a vacant building, that is not vacant land. Vacant land is that is ready for development. And the last thing I want to make clear, because when I've talked to folks in other municipalities that are dealing with this, some think that the municipality is now obligated to build its share of affordable housing units. There's one municipality you can read about on NJ.com that is using land, using eminent domain and trying to take land to fulfill their affordable housing. The municipality has to zone for it. So the municipality doesn't have to go to the bank and get a multi-million-dollar loan to build its housing. It has to allow others, developers, to come in through zoning and permit those developers to build the housing. So that's kind of some process things. On the site that was selected, I do want to say I think it is a good site. I don't think it's a compromise. We are banking on inclusionary zoning, which means for every affordable housing unit, there's 4 market rate. It is in a quarter that's bikeable to a train station, has bus stops along the way, close to Route 10, would be developed at a scale, whether it's 15 or 20 or 17 dwelling units per acre, is appropriate at a scale that we're seeing on that end of town. And again, I don't think we're settled there. I think it's a good plan. That part's my personal opinion. Everything else is just kind of observations on the process that was in the law.
Okay, thank you. Bill Houston has a microphone. I encourage people to ask questions, and we will certainly answer them to the best of our ability. Jim? Bill has a microphone so everybody can hear you.
Just two comments. I think you guys did a great job. You know, I do think affordable housing is something that's needed. You probably all have members that or family or friends that we know that utilize that. So I think getting it down to the number that you did is very good. The question that I have, this is for 10 years, are you already planning for the next 10 years? In other words, how about designating some of this open land possibly to parks to eliminate to take that away from the equation 10 years from now?
So I think the borough positioned ourselves as well as we could at the current state. We did do that. We did make amendments to our master plan that added open space areas within the borough, so it couldn't potentially be touched, right? I guess it could be if they really wanted to take it, it could be, but we tried to protect the borough as best we could through this round and previous rounds as well. So we do have set aside already zoned affordable areas within the borough that hopefully we'll be able to satisfy our next round. But yeah, that forward thinking is always there. And I do want to just say, not to interrupt you, but the borough is not against affordable housing whatsoever. We're for affordable housing. It's the density of the affordable housing. This 5-to-1 or 4-to-1 that everybody's talking about, that's what has to end. It's not building the affordable units. So I just want to make that clear. And I think everybody on the council and the planning board and the committee is all on board with that same statement.
Okay, and just one more comment. When you build affordable housing, you know, are there plans for the architecture of this building yet? The reason why I'm bringing that up is because there's some monstrosity that was built on Route 53, that's a square box. And how that ever got built with that architecture, it devalues all our properties, the way that was built. There's beautiful, affordable housing that I've seen built all over the place, and that looks like a cube. It's terrible. So I hope that when you do build this affordable housing, that the architecture looks good.
So the borough more than likely will not build it. It'll be a developer, and then that will come through the planning board, and then the planning board will have some say of what that building will be able to look like. In front.
Does everyone have a chance of disagreeing with the plan? Any individual or any property owner?
I'm sorry, what was the,
Does any individual or property owner have the ability to disagree with the plan?
yes. Yes.
And that concern, should we be concerned about Sonesta Suites disagreeing with the plan because they're the closest?
I suppose that's a possibility, but I think no matter where you put the zoning, you know, you have the closest neighbors who you always have to contend with, and you know, I would think that from the, and again, this is just mere speculation, but from the vantage point of that kind of use, you know, an extended stay, multifamily use, I think this kind of development would have less impact on that. Actually, I think the new development, proposed development, would have less impact on Sonesta Suites than Sonesta Suites has on the new development. I'd be more concerned, again, from a personal point of view, I'd be more concerned about living across the street from the Sonesta Suites than the Sonesta Suites worried about living across the street from a 30 or 40 unit structure. But yes, anybody can object. They can.
Do we have any intelligence on whether that will be an issue for them, or it could happen the last day that's the clock stops ticking?
I don't have it.
Now, it could happen at any time, it could not happen, but in all actuality, the value of their property has gone up there now. So I really don't know whether they will contest it or not. That's yet to be seen. It could be at 11:59 on the day before the deadline.
Yeah, okay, and I agree with the comment about the architecture of it, or else we might have another McDonald's built over there.
Mayor, would you please explain, because I know that a lot of people don't understand about that affordable housing on Route 53. That is not going to be visible. Would you explain that they are not finished with that development and it will not be visible when they do finish?
Yeah, there are still 3 buildings that are yet to be built there on that Route 53 property going towards Route 10 on the left-hand side. You do see that one standalone building there, and that was part of a settlement agreement that they had to build that in order to get some COs for those market rate units that were built. So there will be 3 other buildings put up there that will almost essentially hide that building, and there's going to be plenty of landscape and architecture out in front of that when that does get further developed.
What's the hold? They have 10 years to do it.
10 years, wow.
Thank you. Am I supposed to give my name and address and social security number?
Everybody here knows who you are, Patty. Go ahead.
Thank you to all of you who have worked hard on this. I can't imagine putting so much time into this, but I'm not a rational person. I'm going to make a comment first, then I'll ask my question. I'm way up here on emotion, and Tom and I happen to have 2 daughters. The older one lives in Jersey City, and she's had a homeless person sleeping in her backyard. He's gone now, but he was there for quite a long time, and they took care of him. Now here we are in Morris Plains, and we're worried. There may be some people who are worried that there could be a few units that don't have people with great financial resources available living there. And of course, we call that NIMBY. And I'm really happy that, and I hope, I have my fingers crossed, that all this will go through. Because I can't, even what's affordable these days, I don't think is affordable. I mean, I don't even think that's an appropriate adjective because it's so damn expensive to buy anything. But anyway, kudos to all of you for attempting to get this to go through. My question jumps way ahead, and that is, what is the process for determining who will live in those facilities? Because there might be, 500 people who fit into one category, income category, but who makes the decision as to who will have the privilege of purchasing and living there?
I'll let the attorney answer.
The borough has an administrative agent who conducts the selection process, and the selection process is a random process. You have to, and I can't tell you the step-by-step process, but in general, it is that it has to be open to any person and household in the region. Okay, so that 4-county region that I talked about, Warren, Union, Morris, and Essex, that's the region that people will come from. Now, I don't expect, a number of people to come from Warren County who are residing somewhere in Warren to come out to Morris, but that can happen, so it's a very large region. The people the households are qualified, income qualified, to make sure that they're in that category of low or moderate. And then after that, I really, I can't tell you the process. I can tell you that it is a random process. It's not it's not who you know, what you know, can you get me into this unit? It's none of that. It is a strictly random process that's utilized to select households. And it's not, it's not easy to do because if they're sales units, you run into a whole series of things because people, the low and moderate income households that occupy sales units, that buy sales units, they are working, they need to qualify for mortgages, and that whole process takes a while to be able to get to that point. Rentals are a little bit easier because it's just income, and eventually, hopefully, you'll be able to continue to afford that unit. But that's all I can tell you about it. I don't get involved and have not been involved in the selection process.
So renting is an option.
If they're rental units, yes. It could be sales units or rental units. Technically, we can't control, the borough, cannot control whether a unit is a sales unit or a rental unit. It's just going to be a unit.
And what if somebody is transferred here or to one of the counties in this region and wants to live in Morris Plains, but does not, and just say that person lives in eastern Pennsylvania? This is sort of a wild question, but would that person be eligible or not because that person doesn't currently live in the region?
I think the answer to that question is no, they would not be. They have to be within the region. They can't live somewhere else. But I don't bet money on that. That's my reaction. I believe that's the case.
Just to answer your question though too, in Appendix G of this document, this 140-page document, there is an adoptive affirmative marketing plan that's already in here that kind of spells that out for you. a detailed plan, where it has to be advertised, how long it has to be advertised, how many counties it has to be advertised in, all sorts of regulations.
So I'd like to say thank you to the committee too, and also to our attorney. You did a very effective job scaring the hell out of us with the 137 and then talking us down to 106, get down to 6. It all sounds very reasonable. Maybe, Mr. Mayor, an opinion on your part. Based on our experience over the last number of years, do you suspect that there are developers ready, willing, and able to take on a project like this?
I think due to the size of this project, we're talking anywhere between, I'll say maybe, between 25 and 35 or so. That, yeah, it would be very marketable. But again, we have 10 years to do this. You have a new governor that may be coming in come November, or starting in January, and this may all change. So, but yeah, I do think, given the size of it, it's nothing huge, so I think it'll attract some other developers, but I think it'll be attractive to developers, sure.
Thank you. This was amazing how you could make this understandable, so complicated, so thank you. And I too would go with what the most recent speaker said, because I did remember the 137, and my head's still spinning a little bit about how we got that down so far. Oh, by the way, I'm Linda DeLapp on Sun Valley Way. My question has to do with the rezoning of this block 112. Just curious how it's zoned now and what it gets rezoned to. And I see it looks like it's covered with trees.
I can look up the other part of the question is answered. I can look up what the current zoning is. I think it's OB1, but I'll check.
Dave will look it up and get back to you. Once again, I did, we were shocked too with the 137, because again, like they've said, you multiply that by 5, right? And so you're up to the 600s again, just about what we put in the borough this last round. So, you think this was a stir to the borough, right? Increasing it by 25%, the residents, all that kind of stuff, services, and to get down to this remarkable number, I think is very good. And, it's a lot less sticker shock now than it was certainly before. But, there were literally hundreds or 100, parcels of property that were shown that we could have been able to build on, dwindling down to where we are is a remarkable feat. So,
Jason, the current zone is OB, which is Office Building District, and it can either be rezoned or an overlay zone provided.
Okay, I have the microphone, sorry.
go ahead.
As everyone knows, today is primary day. And one of the candidates who has a very good chance of becoming our next governor, Mikey Sherrill, has published something she calls her affordability agenda. And in here she says, one of the things is housing, right? And she says she wants to work collaboratively with local governments on the conversion of underused office parks, strip malls, and industrial properties into homes, transit-oriented development, and mixed-use projects while increasing housing inventory, while minimizing sprawl, and provide technical and planning assistance and incentives to municipalities to encourage innovative zoning and redevelopment strategies to build a range of housing units, including for the missing middle. Now, yeah, I know politicians promise a lot of things when they're running for governor, but how impacted will we be if they're looking to, because you said they excluded anything that already had a building on it. So we have like, you know, Acme and City Empty and other places. Do we think there would be a major impact to us if she gets her way on these kind of changes?
Listen, my opinion is this affordable housing is not gonna go away. The one word that I do like in what she says is inclusionary, right? This bill that we're talking about now had no municipality input. It had no municipality sitting on the board. Fair share housing was actually at the table and no municipality was. So if I take anything out of her plan, it's inclusionary, and I hope if she does get elected that she continues with that word inclusionary, because that's very important. To put a blanket on the entire state, one blanket that covers everything is virtually impossible, and that's what this current legislature did when they signed this bill, and Governor Murphy signed this bill. They blanketed the entire state with the same set of rules, and it just doesn't work like that. And here we are, you are spending the money, taxpayers are spending the money to get a number from here down to here that's something that's reasonable for Morris Plains, when, you know, they're giving us the information and the data, and we have to fight it. So, to me, it's an unfunded mandate that the state brought down on us, and so I really hope that she follows through with some of those things that she says, but inclusionary is the key word.
Just another question that comes to mind is, who's the current owner of this property? And does this then set that property up for a bidding war, given that we've targeted this as our affordable housing region?
That's a good question.
Yeah, it's Sonesta Suites is the current owner of that property.
Thank you.
I know, just a quick question. And I know I'm kind of in the minority here because I'm the one, it just seems like the focus has been all along how to bring that number down as far as possible.
Yeah.
When in reality, you know, the housing price, the average median home price in Morris Plains is now $750,000. And on the track we're on in 5 years, it'll be over $1 million. So we desperately need more housing, and yet it seems like everybody here is so focused on building as little housing as we possibly can. And I live in the venue at American, which was, you know, part of this lawsuit that happened in 2015 that got built. So we have, whatever, 156 units, we contribute about $2.5 million of property taxes for the town, no impact on the school. It just seems crazy to me that we'd be suing and spending all this money to fight something that was a clear benefit for the town. I just don't understand why we're so determined to not build any housing.
So like I said, we're not opposed at all to affordable housing, it's the density of the housing. You know, when you build 20 affordable units, that's fantastic, that was our obligation. And we probably wouldn't even fight if it was 137, right? But that's not what you're contending with. You're contending with the 5 other units that bring you up.
But we need the 500, that's my whole point. We need,
Yeah, but
we need 1,000
but the
units.
500 units are 500, 700, $1.2 million, I think they went for over there, some of those units, right?
True.
So those are not the ones that people are looking for affordable housing, right? So to build 20 units, okay, of affordable, and then the rest of them, $1 million units, that doesn't
But
make
true,
any
but
sense either.
those $1 million units, virtually every single one of those units were filled by somebody who moved out of their single-family home, right, which creates a whole cascade of transactions. So like, we had a young couple out of Hoboken bought our house in Chatham so we could move in here, and eventually some family got a house they wouldn't have been able to get because we moved in this $1 million, you know, condo in Morris Plains. It's just, I know we're not gonna solve it, but
Yeah.
I just feel like we're so determined, not just in Morris Plains, every town. And my son, you know, just took a job as a teacher. How in the world is a teacher ever supposed to be able to afford to live anywhere near? Right? He's gonna be working in Chatham. Chatham used to be a middle-class town, right? My brother-in-law grew up there, his parents were teachers. It's 1.3 million median home price in Chatham.
Yeah.
How is a teacher supposed to live there?
Listen, that's a good question, but you're living in one of the richest counties in the United States of America here, and I don't know how to answer your question, but
You could build more housing, that's what would solve it.
the borough isn't building the houses,
Morris
you have
Plains is a
developers
small
that
town.
build.
Where are you gonna put them?
what did we do in the 1970s?
Where
Are
are you going to?
All right, we're not here to argue, we're just not gonna argue it, but everybody has their opinion, so that's fine. If we have a question, we'll move on.
I have a question.
Go ahead.
I'm glad to hear that there are going to be more buildings on that Route 53 property because it's been sitting empty for so long. I was wondering what happened to the commercial properties that were supposed to go in there?
Yes,
Did we
there
get
are-
an update?
Yeah, there are 3 small commercial properties that are on that 5,000 square foot each, so it's 15,000 square feet of commercial property over there, and I believe the number, if I'm not mistaken, is 192 more rental units that are proposed to be built there, and a hotel. They had 10 years to build the hotel. They have to be in their 7th, 8th year, I think, probably by now, so we'll see what happens going forward with that, but there is no real timeline on the building of the rest of the units that are going there.
Thank you. This is the second time I heard a similar presentation, but each time I hear it, I hear different things. So I appreciate all the work that went into this. And I had some feedback on both of the comments that came from Dave and Ed. You both mentioned the fact that you feel this is a strong proposal based on the site location. And I was wondering if there's any criteria from the program, that's what it's called, the program, for scoring a site to identify what makes it a strong location?
In general, there's four criteria that are called UBLs. UBLs are developable, approvable, available, and suitable. So they're lumped together as UBLs. That's the general criteria that is utilized as to whether a site allows for a realistic opportunity for the construction of the housing. And the Housing Element Fair Share Plan goes through those UBLs with regard to this site and finds that, it meets all of those criteria. And that's it. It's not a score of 199 and 75. It's more subjective than numerical.
Okay, because you mentioned proximity to public transportation. I thought I had seen that somewhere in the literature.
I think those are all criteria that people use to create realistic opportunities,
Okay.
But the good thing about the law, if there is a good thing, is that it does defer to the municipal determinations. So, as I said earlier, the burden of proof is not on us. The burden of proof is on the other side to challenge the validity of this site. So they have to figure out, why is this site bad?
Okay.
As opposed to why the site, we don't have to prove why it's good, so
Okay.
long as it meets the UBLs.
Okay, and then there was one more question on the compliance certification. You said possibly in 2026. Could you clarify, what does that mean? Does that mean that that's when our plan that we've prepared with the site and, the size of the building perhaps, is approved? Or is that when we have a developer who has a plan that's been approved and ready to build?
No, it's the former. It's when that plan is approved by the program, that's when it starts. It starts in 2025, goes to 2035. But that certification is on the plan, not the implementation of the plan.
But a plan is not a physical plan of a building with windows here, windows there, and the layout of a building. That's not what he's talking about with a
Okay.
plan.
So once we have that certification, what's the chance that, before we have a next round, that that plan could be challenged? Once we have it certified, that's it, that's the plan?
Yes,
Okay,
yes.
great.
That's by the end of this year, really.
Oh, and then I want to just comment on the affordable housing. I think one of the challenges that we have about building affordable housing is the way our state legislates. What it's called? And that is that a lot of the onus on the infrastructure costs that go along with the affordable housing development is on the municipality, whereas in some states, the developer assumes a portion, at least, of those infrastructure costs that be police and roads and sewers and water and schools and et cetera. But here in New Jersey, that burden falls on the municipality, not on the developer. So that is one of the challenges that we have with increasing our number of units, and you know, being accepting to having more and more, which is what we need, clearly, to your point.
Somebody said something a few minutes ago, and I might have misunderstood it, so stop me. Feel free to stop me.
Stop.
Okay. But you know where I keep thinking, I just used my thumb, right? Somebody said that the hotel owns that property currently, correct?
Sonesta Suites owns that property in front of them, yeah.
Right, so what happens if they don't want to sell? Is it then taken by eminent domain?
No. And when I say Sonesta Suites, or when we say Sonesta Suites, it's the underlying corporate owner. It's a corporation or an LLC that owns this property that is being subject to the rezoning. And it's the same corporate owner that owns the Sonesta Suites property. I'm not sure it's Sonesta Suites as such. Sonesta Suites may be.
It doesn't matter. The name doesn't matter. Somebody owns that property. What happens? People who own Sonesta Suites property owns that property. What happens if they say no, or whoever owns the property? If they say no, we don't want to sell it. It's taken by eminent domain.
Well, it's not a question of selling it. It's all that happens is the property is rezoned or overlay zoned for the affordable housing project that we're talking about. And that's an inclusionary project, market units and affordable units with a 20% set aside. That's all we do. It's up to the property owner if they decide that they're not interested in developing it and they're not interested in selling it, it's gonna sit there. And it's gonna sit there for 10 years.
It's the International Hotel Group.
We have nothing, how does the municipality handle it? So then how does the municipality or the borough handle its affordable housing stake if nothing gets built?
All we have to do, as Dave pointed out, is provide realistic zoning. So long as the property is zoned and is able to produce these number of units. For example, we wouldn't be able to rezone a piece of property that is completely in regulated wetlands where you can't build and say, okay, we're going to rezone that for 50 units, 20% set aside, 10 affordable units, but it can never be built upon because the regulations don't allow building in wetlands. That's something we can't do. But if it meets the UBLs, which is what I mentioned earlier, then all we have to do is rezone it, and then it's up to property owners. Municipalities are not obligated to build the housing. They're obligated to provide a realistic opportunity. Now, to be candid, if 5 years, 6 years, 7 years goes by and nothing happens with that property, there may be questions raised because there are interim reviews I think it's every 5 years. So in the 5th year, there'll be an evaluation, where's this property going, what's happening with it, what's going on, and we'll have to deal with that when it arrives. I mean, I don't know what's gonna happen with that.
It's not that we have to do eminent domain at all,
Oh, no.
no, that's not even in the cards, it's not in the picture.
But I do want to add, if I could, and this is completely speculative and my personal opinion, right, not representative of the borough. I think, so the owner owns this parcel today that is zoned OB. How many office buildings are getting built new today? Right, you've had a comment before, right? There's a glut, right, so looking to adaptively reuse. How many hotel beds are needed for them to build another hotel bed there? Probably not good. I think this is an opportunity for increased utility and increased value that this owner now has available to them. And I think it makes the parcel attractive to development and that attractiveness didn't exist prior to the housing fair share plan.
Just one thing I want to piggyback also on what Nancy had said, and this is going to you, Bill. The borough was asked, I'll say, we were asked to provide water to 300-unit development in Harding. The council and myself, we weren't very happy with that. We told them no. We ended up getting sued to supply water to Harding, who does not have the resources to build or have these utilities, on a site for their obligations. So, the Southeast Morris Water Utilities Authority now is supplying water into Harding for a 300-unit development when we have units and buildings going on here and the 4 towns that are involved with that utility that also need those resources. So, you get into situations like that where you're supplying other utilities or equipment or whatever it may be to other municipalities to satisfy just their obligation for affordable housing. So it gets to be pretty sticky. Anybody else?
So, Mr. Mayor, I just have one point of clarification that I want. When it comes to actually, designing the units that go there, right, or designing the structure that goes there, I believe the planning board has say over what that's going to look like, what it's going to be, as long as it meets the obligation, correct?
Correct.
Okay. I know somebody was asking before about the design and what it's going to look like, so that's going to go before the
for the
plan.
planning board, sure.
Right, okay, thank you.
I think I answered that, by the way. Okay, Rex, you have no other?
Zoning would say if you have to have covered garages and stuff like that, right?
Hold on.
Whatever zoning you do, it would have to say whether you have to provide covered garages or the town can put requirements on how they build. Because I know like the ones that were built off of Johnson Way, I think they have like a parking garage, indoor parking garage there, right?
Yeah, Signature Place? Where you're talking
Yeah,
about?
that's.
Yeah, yeah.
So you have some control over.
The borough will have some control over the aspect of affordable
It
building.
can't be like 10 stories tall or.
Well, hopefully not, that's what we're trying to avoid, but we do have control over that. Well, there's already,
RSIS standards?
Yeah.
Yeah.
yes, there already are standards that the developer would have to follow.
And in the housing element fair share plan, there's an abbreviated zoning ordinance that gives you some idea, but there's more meat on the bones that have to be put in there in terms of design criteria and those kinds of things. And if you look at some of the zoning ordinances for the multifamily developments, you'll see, the detail that is typically contained in the ordinances.
Okay, seeing nobody else, I don't want to cut anybody off.
Excuse me, I'm sorry.
Oh, I'm sorry.
I snatched the microphone.
Okay.
Well, again, thanks to everyone. This is it's wonderful to hear that we're going down to 6. I wonder if you happen to know if the towns in our area, back in November, in a Plains talk, you mentioned that there's a potential for 10,000 new units based on this 4th round housing obligation.
Correct.
We've done our part. Do you know if the other towns are also able to reduce theirs? And I'm thinking, of course, of the traffic and congestion in the area.
So, I know one town has, one may be in court still in litigation. I believe Hanover Township have. I haven't got everybody's numbers yet, so, but I know they've been reduced. Yeah. But you're still gonna have traffic and, even with our little building, if you put 25 times 2 cars at least, right? So there's 50 cars there, right? So, it's gonna increase no matter what. There's no more real estate for roads, so.
So I have a quick question. You're saying that 4 or 5 units have to be built. Is that part of the law that, you're saying 10 units, you gotta build 50 units? Is that part of the law? Like they built it in that these builders have to do that? Or are allowed to do that? I don't know, which is it?
Well, The obligation that is imposed is the affordable housing obligation, affordable housing units. The municipality can satisfy that affordable housing obligation in a number of ways. One way is to have developers satisfy that obligation, private developers building multifamily projects. The standard that's utilized is if a private developer is going to develop a project, it is done economically, and I don't have statistics on this, I don't have any source data, but the standard is that a private developer can build one affordable unit for every 4 market units that he builds, because the 4 market units will produce enough profit to subsidize the low-income units. So that's where the 20% come in. A municipality does not have to satisfy its obligation through private development. That's what we're proposing here, but in the 3rd round, for example, one of the components of Morris Plains' plan was the 100% affordable project that's on Route 53, the 54 units or 57 units. There's no market units. Those are all affordable units.
Does the
But-
town still own that? So you're collecting rental
Right.
on that?
But the township also the borough also had to pay for that.
Yeah, no.
That's the difference, I mean.
And I get it, and that's
Yeah,
why
and
I'm
that's it.
asking,
Yeah.
the builders are allowed to make their profit. And,
Yes,
but it's not the law.
that's correct. You don't have to satisfy it that
But
way.
it's just kind of implied that, yeah, follow the money.
But we, the borough, or a municipality, that's not unique to Morris Plains, they can determine how they're going to satisfy their obligation. So, we could have said, or we, the borough, could have said, okay, we have a 10-unit obligation, let's build a 10-unit, 100% affordable project. We'll issue bonds for $5 billion, we'll build a project, and we only have to deal with 10 units. We'll find a site and do all that. That's an option that they could do, but that puts a burden on, obviously, the taxpayers to pay the debt service on $5 billion in debt to build it. As I said, part of those 10 units, the 10-unit obligation is being satisfied through existing group home, bedrooms in group homes. We have a couple. So there's a whole menu of ways in which you're able to satisfy your obligation. The one that is predominant, I think, in the state is private industry, the private developer doing these inclusionary projects. And with that, as has been pointed out by virtually everybody here, there's a tremendous impact on the community, traffic, schools, services, just everything, because you can only fit so many potatoes in a 10-pound bag, I guess is.
And I do want to say you did a very nice job of explaining it. It really did highlight everything and make it understandable. Thank you.
Thank you.
Again, thank you. A special thanks, I really thank everybody up here in the council and the committees and the planning board, and everybody up here, our professionals, but really I want to thank Mark Mayer tonight and the superintendent of the schools here and the custodial staff. We had elections over at the community center. They had an award ceremony over at the STEM center of the school, and they allowed us to use this. So again, I want to say thank you to them. And it's another shared service that we do here in the borough. So I really want to extend a thank you. And I really extend a thank you to all you coming out tonight and asking very intelligent questions and being part of this. So we're here all the time. You can reach out at any time if anything should come up any further. So thank you very much. Thank you.